Hello, are you ready for our new discussion? Let's start.
Good day. For today's video, we will going to read the case of Salvacion versus Central Bank of the Philippines 278 Supreme Court Reports annotated 27. And we will explain what makes it an exception to Republic Act 6426, or also known as an act instituting a foreign currency deposit system in the Philippines and for other purposes. General Rule number 94723, August 21, 1997, Karen E. Salvacion Minor through Federico N. Salvacion Jr., father and natural guardian, and spouses Federico N. Salvacion Jr. and Evelina E. Salvacion petitioners, versus Central Bank of the Philippines, China Banking Corporation, and Greg Bertelli E. Northcutt, respondents. Taurus Jr. J. In our predisposition to discover the original intent of a statute, courts became the unfailing pillars of the status quo. Legal do we realize that statutes or even constitutions are bundles of compromises thrown our way by their framers. Unless we exercise vigilance, the statute may already be out of tune and irrelevant to our day. This petition is for declaration relief. It prays for the following reliefs. Immediately upon the filing of this petition, an order be issued restraining the respondents from applying and enforcing Section 113 of the Central Bank Circular Number 960. After hearing judgment be rendered. First, declaring the respective rights and duties of petitioners and respondents. Second, adjudging Section 113 of Central Bank Circular Number 960 are contrary to the provisions of the Constitution, hence void, because its provision that foreign currency deposits shall be exempt from attachment, garnishment, or any other order or process of any court, legislative body, government agency, or any administrative body whatsoever, has taken away the right of petitioners to have the bank deposit of defendant Greg Bertelli E. Northcutt garnished to satisfy the judgment rendered in petitioners' favor in violation of substantive due process granted by the Constitution, has given foreign currency depositors an undue favor or a cash privilege in violation of the Equal Protection Clause of this Constitution, has provided a safe haven or criminals like the herein respondent Greg Bertelli E. Northcutt, since criminals could escape civil liability for their wrongful acts by merely converting their money to a foreign currency and depositing it in the foreign currency deposit account with authorized bank. Here are the antecedent facts. On February 4, 1989, Greg Bertelli E. Northcutt, an American tourist, cooked and lured petitioner Karen Salvacion, 12 years old, to go with him to his apartment. Then therein, Greg Bertelli detained Karen Salvacion for 4 days or up to February 17, 1989, and was able to rape the child once on February 4 and 3 times each day on February 5, 6, and 7, 1989. On February 7, 1989, after policemen and people living nearby rescued Karen, Greg Bertelli was arrested and detained at the Makati Municipal Jail. The policeman recovered from Bertelli the following items. On February 16, 1989, Makati Investigating Fiscal Edwin G. Gundaya filed against Greg Bertelli criminal case number 801 for serious legal detention and criminal cases numbers 802, 803, 804, and 805 for 4 counts of rape. On the same day, petitioners filed with Regional Trial Court of Makati civil case number 89-3214 of damages with preliminary attachment against Greg Bertelli. On February 24, 1989, the day there was a scheduled hearing for Bertelli's petition for bail, the latter escaped from jail.
On February 28, 1989, The court granted the fiscal's urgent ex parte motion for the issuance of warrant arrest and hold departure order. Pending the arrest of the accused Greg Bartelli in Northcott, the criminal cases were archived in an order dated February 28, 1989. So what do you mean by ex parte? So in civil procedure, ex parte is used to refer to motions for orders that can be granted without waiting for a response from the other side. So generally, these are orders that are only in place until further hearings can be held, such as a temporary restraining order. Meanwhile, in civil case number 893214, the judge issued an order dated February 22, 1989, granting the application of herein petitioners for the issuance of the writ of preliminary attachment. After the petitioners gave bond number GCL 4 1981 by FGU Insurance Corporation in the amount of 100,000 pesos, a writ of preliminary attachment was issued by the trial court on February 28, 1989. So a writ of preliminary attachment is defined as a provisional remedy issued upon order of the court where an action is pending to be levied upon the property or properties of the defendant therein. So the same to be held thereafter by the sheriff as a security for the satisfaction of whatever judgment might be secured in said action by the attaching creditor against the defendant. On March 1, 1989, the Deputy Sheriff of Makati served a notice of garnishment on China Banking Corporation. In a letter dated March 13, 1989 to the Deputy Sheriff of Makati, China Bank Corporation invoked Republic Act No. 1405 as it answers to the notice of garnishment served on it. What are the content of the Republic Act No. 1405? So it is an act prohibiting disclosure of or inquiry into deposits with any banking institution and providing penalty thereof. On March 15, 1989, the Deputy Sheriff of Makati, Armando de Guzman, sent his reply to China Bank Corporation saying that the garnishment did not violate the secrecy of bank deposits since the disclosure is merely incidental to a garnishment properly and legally made by virtue of a court order which has placed the subject deposits in custodia legis. So custodia legis, it is a Latin phrase which means in the custody of the law. So in answer to this letter of the Deputy Sheriff of Makati Banking Corporation, in a letter dated March 20, 1989, invokes Section 113 of Central Bank Circular Number 960 to the effect that the dollar deposits or defendant Greg Bertelli are exempt from attachment, garnishment, or any other order or process of any court, legislative body, government agency, or any administrative body or whatsoever. So, this prompted the Council for Petitioners to make an inquiry with the Central Bank in a letter dated April 25, 1989, on whether Section 113 of CB Circular 960 has any exceptions or whether said section has been repealed or amended since said section has rendered nugatory the substantive rights of the plaintiff to have the claim sought to be enforced by the civil action, secured by the writ of preliminary attachment as granted to the plaintiff under Rule 57 of the Revised Rules of Court. So the central bank responded to a letter dated April 25, 1989 regarding the inquiry on Section 113 CB Circular Number 9603. And the letters of the content is that the cited provision is absolute in application. It does not admit of any exception, nor has the same repealed nor amended. So the purpose of the law is to encourage dollar accounts within the country's banking system, which would help in the development of the economy.
Meanwhile, on April 10, 1989, the trial court granted petitioner's motion for leave to serve summons by publication in the civil case number 893214 entitled Karen Salvacion et al. Versus Greg Bartley in Northcott. Summons with the complaint was published in the Manila Times once a week for 3 consecutive weeks. Greg Bartley failed to file his answer to the complaint and was declared in default on August 7, 1989. After hearing the case ex parte, the court rendered judgment in favor of petitioners. On March 29, 1990, the dispositive portion of which reads, "Wherefore, judgment is hereby rendered in favor of plaintiffs and against defendant, ordering the latter. First, to pay plaintiff Karen E. Salvacion the amount of 500,000 pesos as moral damages. Second, to pay her parents, plaintiff's spouses, Federico N. Salvacion Jr. and Evelina E. Salvacion the amount of 150,000 pesos each, or a total of 300,000 pesos for both of them. Third, to pay plaintiffs exemplary damages of 100,000 pesos and to pay attorney's fees in an amount equivalent of 25% of the total of damages herein awarded. Fifth, to pay litigation expenses of 10,000 pesos plus cost of the suit, so ordered." The heinous acts of respondent Greg Bartley, which gave rise to the award, were related in graphic detail by the trial court in its decision as follows. The defendant in this case was originally detained in the municipal jail of Makati, but was able to escape therefrom on February 24, 1989, as per report of the jail warden of Makati to the preceding judge, Honorable Manuel M. Cosico, of the Regional Trial Court of Makati, Branch 136, where he was charged with 4 counts of rape and serious illegal detention, crime cases numbers 802 to 805. Defendant, however, failed to file his answer to the complaint despite the lapse of the period of 60 days from the last publication. Hence, upon motion of the plaintiffs through counsel, defendant was declared in default and plaintiffs were authorized to present their evidence ex parte. In support of the complaint, plaintiffs presented as witnesses the minor Karen E. Salvacion, her father, Federico N. Salvacion Jr., a certain Joseph Aguilar, and a certain Liberato Madolio, who gave the following testimony.
Karen took her first year high school in St. Mary's Academy in Pasay City, but has recently transferred to Arellano University for her second year. In the afternoon of February 4, 1989, Karen was at the Plaza Fair, Makati, and Cinema Square with her friend Edna Tangeli, whiling away her free time. At about 3:30 p.m., while she was finishing her snack on a concrete bench in front of Plaza Fair, an American approached her. She was then alone because Edna had already left and she was about to go home. The The American asked her name and introduced himself as Greg Bartelli. He sat beside her when he talked to her. He said he was a math teacher and told her that he has a sister who is a nurse in New York. His sister allegedly has a daughter who is about Karen's age and who was with him in his house along Kalayaan Avenue. The American asked Karen what was her favorite subject and she told him it's Filipino. He then invited her to go with him to his house where she could teach Filipino to his niece. He even gave her a stuffed toy to persuade her to teach his niece. They walked from Plaza Fair along Pasantamo, turning right to reach the defendant's house along Kalayaan Avenue. When they reached apartment house, Karen noticed that the defendant's allegedly niece was not outside the house, but defendant told her maybe his niece was inside. When Karen did not see the alleged niece inside the house, defendant told her maybe his niece was upstairs and invited Karen to go upstairs. Upon entering the bedroom, defendant suddenly locked the door. Karen became nervous because his niece was not there. Defendant got a piece of cotton cord and tied Karen's hands with it, and then he undressed her. Karen cried for help, but defendant strangled her. He took a packing tape and covered her mouth with it, and he encircled it around her head. Then, defendant suddenly pushed Karen towards the bed, which was just near the door. He tied her feet and hands spread apart to the bed post, and then he molested her.
The following day, February 5, 1989, Sunday, after Karen ate breakfast, lunch, and dinner, she was raped by the defendant even if she was still bleeding. During those 3 times, the defendant succeeded in inserting his sex organ, but Karen could not say whether the organ was inserted wholly. Karen did not see any firearm or bladed weapon. The defendant did not tie her hands and feet nor put a tape on her mouth anymore. All the windows and doors were closed. Karen did not cry for help because of fear that she might be killed, and even if she shouted for help, nobody would hear her, and besides, the defendant did not leave that Sunday. She was afraid if somebody would hear her and that would be able to call the police, it was still possible that she was still inside the house, the defendant might kill her. On February 6, 1989, Monday, Karen was raped 3 times. Once in the morning, again in the afternoon, and again in the evening. At first, Karen didn't notice there was a window because it was covered by a carpet until that the defendant opened the window for around 15 minutes or less to let some air in. And Karen found out that the window was covered by styrofoam and plywood. After that, he again closed the window with a hammer and he put the styrofoam, plywood, and the carpet back. On that night, she had a chance to call for help since the defendant left, but still the door were closed. She went to the bathroom, saw a small hole, and tried to call for help. A woman heard her, but the woman got angry. And still Karen pleaded for help, and the woman told her to sleep and she will call the police. She finally fell asleep, but no policeman came. In the following morning, Karen woke up at 6 o'clock and saw the defendant in bed sleeping. On that day, February 7, 1989, she was again raped 3 times. The defendant left for a short while after he raped her in second time. Upon his return, he cuffed her shouting for help, but he did not understand what she was talking about. After she was raped in third time, the defendant left, and this time she got helped. And the woman said, that they will call the police and ask her to change clothes. She did not change her clothes because she was afraid that the defendant see her in different clothes, he might kill her. Afterwards, the defendant arrived. He asked her if she shouted for help because there are many policemen outside, and Karen denied. He told her to change her clothes and she did, the one that she wearing on Saturday. He instructed her to tell the police that she left home willingly. Then he went downstairs and locked the door. When she heard the voices of many people who were conversing downstairs, she knocked repeatedly at the door as hard as she could. A policeman went upstairs and asked her name and the reason why she was there. She told him she was kidnapped. They went to substation 1 and there she was investigated by a policeman. And about 2 a.m., her parents arrived. Then they were brought to the second floor of the police headquarters and there she was asked several questions by the investigator. The written statement she gave to the police was marked as Exhibit A. Then they proceeded to the National Bureau of Investigation together with the investigator and her parents. At the NBI, a doctor, a medical legal officer examined her private parts. Pursuant to an order granting leave to publish notice of decision, said notice was published in Manila Bulletin in once a week for 3 consecutive weeks. After the lapse of 15 days from the date of publication of notice of judgment and decisions of the trial court had become final, petitioners tries to execute on Bartelia's dollar deposits with China Banking Corporation. Likewise, the bank invoked Section 113 of the Central Bank Circular number 960.
Hi everyone, I am Christy Bongo. So the issues raised and the arguments articulated by the parties boil down into 2. So may this court entertain the instant petition despite the fact that original jurisdiction in petitions for declaratory relief rests with the lower court? Or should Section 113 of Central Bank Circular number 960 and Section 8 of Republic Act 6426 as amended by PD 1246, otherwise known as the Foreign Currency Deposit Act, be made applicable to a foreign transient? So, petitioners aver, as heretofore stated, that Section 113 of Central Bank Circular number 960, providing that foreign currency deposits shall be exempt from attachments, garnishments, or any other order or process of any court, legislative body, government agency, or any administrative body whatsoever, should be adjudged as unconstitutional on the grounds that, first, it has taken away the right of petitioners to have the bank deposit of defendant Greg garnished to satisfy the judgment rendered in petitioners' favor in violation of substantive due process guaranteed by the Constitution. Second, it has given foreign currency depositors an undue favor or a class privilege in violation of the Equal Protection Clause of the Constitution. Third, it has provided a safe haven for criminals like the herein responded Greg, since criminals could escape civil liability for their wrongful acts by merely converting their money to a foreign currency and depositing it in a foreign currency deposit account with an authorized bank. And fourth, the Monetary Board, in issuing Section 113 of Central Bank Circular number 960, has exceeded its delegated quasi-legislative power when it took away the plaintiff's substantive right to have the claim suit to be enforced by the civil action secured by way of the writ of preliminary attachment as granted by Rule 57 of the Revised Rules of Court, and The plaintiff's substantive right to have the judgment credit satisfied by way of the writ of execution out of the bank deposit of the judgment debtor as granted to the judgment creditor by Rule 39 of the Revised Rules of Court, which is beyond its power to do so. On the other hand, Respondent Central Bank and its comment alleges that the Monetary Board, in issuing Section 113 of Central Bank Circular Number 960, did not exceed its power of authority because the subject section is copied verbatim from a portion of Republic Act Number 6426 as amended by PD 1246. Since it was not the Monetary Board that grants exemptions from attachment or garnishments to foreign currency deposits, but the law itself that does not violate the substantive due process guaranteed by the Constitution because it was based on a law. The law seems to be reasonable and it is enforced according to regular methods or procedure, and it applies to all members of a class. It is worth mentioning that RA Number 6426 was enacted in 1983, or at a time when the country's economy was in shambles, so when foreign investments were minimal, and presumably this was the reason why said statute was enacted. But the realities of the present times shows that the country has recovered economically, and even if not, the question law still denies those entitled to due process of law for being unreasonable or oppressive. So the intention of the question law may be good when enacted. The law failed to anticipate the effects producing outright injustice and inequality, such as the case before us. So the resolution of this question is important for the protection of nationals who are victimized in the forum by foreigners who are merely passing through.
As a continuation, respondents China Banking Corporation and Central Bank of the Philippines refused to honor the writ of execution issued in the civil case number 893214 on the strength of the following provision of Central Bank Circular number 960. Section 113, exemption from attachment, foreign currency deposits shall be exempt from attachment, garnishment, or any other order or process of any court, legislative body, government agency, or any administrative body whatsoever. The Central Bank Circular Number 960 was issued pursuant to Section 7 of Republic Act Number 6426. Central Bank Circular Number 960 was issued pursuant to Section 7 of Republic Act Number 6426. So Section 7, the rules and regulations, the Monetary Board of the Central Bank shall promulgate such rules and regulations as may be necessary to carry out the provisions of this Act, which shall take effect after the publication of such rules and regulations in the Official Gazette and in a newspaper of national circulation for at least once a week for 3 consecutive weeks. In case the Central Bank promulgates new rules and regulations decreasing the rights of depositors, the rules and regulations at the time the deposit was made shall govern. The aforementioned Section 113 was copied from the Section 8 of Republic Act Number 6426 as amended by PD 1246. Thus, Section 8, Secrecy of Foreign Currency Deposits. All foreign currency deposits authorized under this Act as amended by Presidential Decree Number 1035, as well as foreign currency deposits authorized under Presidential Decree Number 1304 are hereby declared as and considered of an absolute confidential nature and exempt upon the written permission of the depositor. In no instance shall such foreign currency deposits be examined, inquired, or looked into by any person, government official, bureau, or office, whether judicial, or administrative, or legislative, or any other entity, whether public or private, provided, however, that said foreign currency deposits shall be exempt from attachment, garnishment, or any other process or order of any court, legislative body, government agency, or any administrative body whatsoever. The purpose of PD 1246 in according protection against attachment, garnishment, and other court process to foreign currency deposits is stated in its whereas vis. Whereas, under Republic Act number 6426 as amended by Presidential Decree number 1035, certain Philippine banking institutions and branches of foreign banks are authorized to accept deposits in foreign currency. Whereas, under provision of Presidential Decree number 1034 authorizing the establishment of an offshore banking system in the Philippines, offshore banking units are also authorized to receive foreign currency deposits in certain cases. Whereas, in order to assure the development and speedy growth of the foreign currency deposit system and the offshore banking system in the Philippines, certain incentives were provided for under the two systems, such as confidentiality subject to certain exceptions and tax exemptions on the interest income of depositors who are non-resident and are not engaged in trade or business in the Philippines. Whereas, making absolute the protective cloak of confidentiality over such foreign currency deposits, exempting such deposits from tax, and guaranteeing the vested rights of depositors would be better encourage the inflow of foreign currency deposits into the banking institutions authorized to accept such deposits in the Philippines, thereby placing such institutions more in a position to properly channel the same to loans and investments in the Philippines, thus directly contributing to the economic development of the country. Thus, one of the principal purposes of the protection accorded to foreign currency deposit is to assure the development and speedy growth of the foreign currency deposit system and the offshore banking in the Philippines. It is in the third whereas. And then the offshore banking system was established by PD number 1034. In turn, the purposes of PD 1034 are as follows. Whereas conditions conducive to the establishment of an offshore banking system, such as political stability, a growing economy, and adequate communication facilities, among others, exist in the Philippines. Whereas, it is in the interest of developing countries to have as wide as possible to the sources of capital funds for economic development. Whereas, an offshore banking system based in the Philippines will be advantageous and beneficial to the country by increasing our links with foreign lenders, facilitating the flow of desired investments into the Philippines, creating employment, opportunities, and expertise in international finance, and contributing to the national development effort. Whereas the geographical location, physical and human resources, and other positive factors provide the Philippines with a clear potential to develop as another financial center in Asia. On the other hand, the foreign currency deposit system was created by PD number 1035. Its purpose is as follows, as you can see in the slides. It is evident from the whereas clauses that the offshore banking system and the foreign currency deposit system were designed to draw deposits from foreign lenders and investors. It is these depositors that are induced by the two laws and given protection and incentives by them. Obviously, the foreign currency deposit made by a transient or a tourist is not the kind of deposit encouraged by PD numbers 1034 and 1035, and given incentives and protection by said laws because such depositor stays only for a few days in the country and therefore will maintain his deposit in the bank only for a short time. Respondent Greg Bartili, as stated, is just a tourist or a transit. He deposited his dollars with respondent China Banking Corporation only for safekeeping during his temporary stay in the Philippines. For the reasons stated earlier, the Solicitor General thus submits that the dollar deposits of the respondent Greg Bartili is not entitled to the protection of Section 113 of Central Bank Circular number 960 and PD number 1246 against attachment, garnishment, or other court processes. In fine, the application of the law depends on the extent of its justice. Eventually, if we rule that the questioned Section 113 of Central Bank Circular Number 960, which exempts from attachment, garnishment, or any other order or process of any court, legislative body, government agency, or any administrative body whatsoever is applicable to a foreign transit. Injustice would result especially to a citizen aggrieved by a foreign guest like accused Greg Bartile. This would negate Article 10 of the new Civil Code, which provides that in case of doubt in the interpretation or application of laws, it is presumed that the lawmaking body intended right and justice to prevail. Simply stated, when the statute is silent or ambiguous, this is one of those fundamental solutions that will respond to the vehement urge of conscience. It will be unthinkable that the questioned Section 113 of Central Bank Number 960 will be used as a device by accused Greg Bartile for wrongdoing, and in so doing, acquitting the guilty at the expense of the innocent. We definitely cannot have both ways and rest in the belief that we have served the end of justice. In view thereof, the provisions of Section 113 of Central Bank Circular Number 960 and PD Number 1246, insofar as it amends Section 8 of the RA 6426, are hereby held to be inapplicable to this case because of its peculiar circumstances. Respondents are hereby required to comply with the writ of execution issued in Civil Case Number 893214, Karen Salvacion et al. Versus Greg Bartile in Northcott, by Branch 144, RTC Makati, and to release to petitioners the dollar deposit of respondent Greg Bartile in Northcott in such amount as would satisfy the judgment. So ordered.